Today's keynote address is going to be given by Professor and Rabbi Michael Broyde. Rabbi Broyde, Professor Broyde is professor at Emory Law School and head of the Center.
Study for Law and Religion.
The Center for the Study of Law and Religion there at Emory. He is the author of multiple books and more than 100 articles. And with no further ado, I'll give you Professor Broyde.
Thank you very much. It's a pleasure to be here. It's been one of the better conferences I've ever been to. Fascinating. It's not a tribute to me, this is a tribute to the two organizers who should stand up, three organizers who should stand up and take a round of applause. The title of my lecture, Suggestions for Shari'a Courts Based on the Precedents of the Beth of America, is wrong. And it's important to start with that observation first and foremost. I wrote the title, and it wasn't wrong in its transcription, it's just wrong. And I want to explain to you why. That which I'm proposing today are not really suggestions for Shari'a courts specifically and uniquely in any way. A grand transformation has taken place in America over the last 50 years in which dominant religious traditions that previously controlled the tone and tempo of public discourse are now themselves minority religions. America is, in my view, no longer a Christian country in its ethos or ethics. It's really a secular country in its ethos and ethos. And things that historical minority religions like Judaism have been perfecting for a long time will now become cultural techniques to develop community by other minority religions, such as evangelical Christianity, or Roman Catholicism, or Mormonism, which is no longer even really a majority of the faithful, even in its home state of Utah. Never mind such minoritarian religions as Judaism or Islam, or Hinduism, or other, if you'll excuse me, deviant religions, and I classify myself as one of them. I don't mean the term in anything other than its historical way. What we're describing happening in America is not a phenomena of Islamic courts, not a phenomena of Jewish law courts. It's a much broader phenomenon. As the secular society becomes secular, and it's not a Christian country anymore like it was 130 years ago, all of us who want to take our faith seriously, in whatever way that exactly means, and that varies from faith to faith, no longer can rely on the secular legal culture to do so. Our divorce laws no longer reflect evangelical Christianity. They no longer reflect Catholicism. Our laws of sexual morality no longer reflect the historical alliance of the Judeo-Christian tradition. What we are living in now is a secular society. I'm not uncomfortable or opposed to that. I'm describing it. I think that's the way it is. And those of you who don't think we're there today, you will see that we're there tomorrow. I think, in fact, we were there yesterday already. But maybe some of you are living a little bit more behind the times than I am. But it's important to understand that the experience of the faithful Jewish community in establishing rabbinical courts is grounded in nothing less than the desire to have a community. And the community that's made up of the faithful, that functions in accordance with its own norms. It used to be something that only the Jews had to do, because there were really only 3 faith groups in the United States. There were a smattering of Jews, but concentrated in the Northeast. There were Catholics, frequently dominant culturally in many northeastern states, and evangelical Protestants who were dominant in the South. And somewhere out in the West, in a state called Utah, there were Mormons, but who really ever met one. But in their own community, they were dominant. And they used the secular rules to establish their rules. Only the Jews, who were not dominant in any area, had to develop a different set of rules for being a minority culture. But it's important to invoke a deity. Thank God, the country is now fully secular. And no faith group is really dominant anywhere. No faith group really lays claim to realistic control of state government. Maybe that's not true. Maybe the truth is that there are parishes in Louisiana where that's not true. And maybe there's even a state or two, what they call in the Georgia area, the tri-state area. The tri-state area, I think they call Louisiana, Mississippi, Alabama. You could make a claim that maybe there are still religious communities that have effectively grabbed the organs of government. But in most states, that's not the case. And in no provinces in Canada where Rabbi Dr. Novak is from is that the case. And it's certainly even less the case in Europe, where historically Catholic countries are not. Historically Protestant countries are not. The last time the Pope went to visit Germany, 1 million Germans took to the streets along the roadway wearing condoms over them to mock him. They might be Catholic in their vaguest affiliation, but the idea that there's a European country, at least in Western Europe, that's Catholic in its ideology is long since gone. Maybe Poland. But that's maybe today and not tomorrow. What we're describing here is how minority religious cultures build legal systems that work in a dominantly secular society, or in a society in which they don't control the organs of government, but the government is gracious enough to grant alternative dispute resolution status. It will enforce and recognize contracts between parties to resolve disputes consistent with their religious tradition. The majority culture doesn't even have to do that. The majority culture could, as the United States did for quite a period of time, say, everything goes to the courts. Alternative dispute resolution contracts are a nullity. But that's not been the law in the United States for many, many, many years. And the government happily recognizes the rights of parties to opt out of vast amounts of secular law through contract. Prenuptial contracts, business dispute contracts, almost any other contract can be adopted out of. And the United States government has made this clear through something called the Federal Arbitration Act, which requires, this is a very important word, that contracts of arbitration be subject only to cursory review. Michael Helfand is an expert on the details of that review, and his presentation was an excellent analysis of that. But in the biggest picture, we can say that most of the time, a properly executed arbitration agreement to enforce religious law will be enforced by the society that we are part of under the Federal Arbitration Act, which creates a framework for reviewing such arbitrations grounded in fraud or bias, rather than grounded in, are they applying American law? The government could have said, of course you can arbitrate, but all arbitrations shall only be done in accordance with the relevant law of the jurisdiction. The government did not say that. And indeed, I speculated before that I think in the United States the government would enforce a totally arbitrary arbitration agreement if the parties agreed to it. As an example of this, I think if you and I agreed to conduct our business disputes according to the Uniform Commercial Code with the proviso that every fifth word be deleted, which would make it virtually unintelligible and produce almost ridiculous results. If you agreed to it and I agreed to it, the government would delete every fifth result and say, please enforce the law that you've agreed to. The government of the United States and of the UK as well, and mostly in Canada, although not universally, is perfectly willing for you or me to enter into an agreement of arbitration in which we say the Uniform Commercial Code with every sixth word deleted, or something even more mysterious, such as halakha, or sharia, or any other legal system that we want to make reference to. It doesn't really matter. And the government happily says, resolve your disputes that way, so long as you sign an agreement to arbitrate beforehand. And of course, the government makes the obvious limitations on these contracts. I cannot point a gun at you and say you must agree to be arbitrated by Jewish law or I will kill you. Then what do you say? Where do I need to sign? But that's not valid. And it says, of course I can't pay off the judge. And of course I can't engage in other gross misconduct. But more or less, in the face of an arbitration proceeding grounded in Jewish law, the government says, thank you very much. Thank you for relieving the secular courts of the burden of resolving this dispute. Please resolve it yourself in accordance with your contract. And this is true throughout most of Europe as well. And this is the legal regimen that the Jewish tradition has used for centuries. And it has something to show as to how to go about doing this. But what it's going to show has nothing really to do with the unique Jewish tradition or the unique Islamic tradition, although details are important, or the unique evangelical Christian tradition. I occasionally get calls in Georgia from evangelical churches wanting to talk to me about contracts of arbitration in accordance with evangelical law. It would make my Yiddish-speaking grandmother happy to know that I'm consulted on such matters, but no more so than it would make her happy to know that I provide such advice to Islamic courts as well. What we're doing here is we're providing a model for minority cultures to put forward contracts that allow them to opt out of many, but of course not all parts of secular society. That's what we're doing here, and that lesson, which is very much a part of the Jewish tradition, is becoming part of the Islamic tradition, and is becoming part of many other traditions as well. I wish to share with you the 6 secrets of how to do this, but of course they're not secrets. If they were secrets, I wouldn't let them videotape them. They're easy recipes for how to build binding arbitration that the secular government is happy to enforce. First and foremost, the laws of the United States with regard to arbitration have no notion of substantive due process. The government does not know what is the right resolution of your case. The government only has a notion of procedural due process. The Federal Arbitration Act and the myriad of state laws that derive from it have a notion of procedural due process. It explains to you, as you run an arbitration panel, certain things you may and may not do. You may not call a hearing at 4 in the morning on Christmas Day. It's a federal holiday. You must provide litigants with a reasonable amount of notice. In New York State, 8 calendar days. Other states have slightly different rules. You must conduct your hearing in a language that the parties understand. The judges may not have a financial interest in the resolution of the case or the parties. All of these are not substantive rules as to what the judges apply. These are procedural rules that explain to you who may judge cases, when, and where, but not what law they look at. So the first thing that rabbinical courts do, the Beth of America has done, is it has written legally sophisticated rules of procedure. It has said to the secular community, we recognize that what will determine whether you honor our rules is not whether you agree with the substantive provisions of Jewish law. Not at all. What determines whether you will honor our rules is whether we follow procedural due process. So if you go on the Beth of America website, bethdin.org, you will see one of the links says to our rules. And there are 35 rules. They look eerily like, how many of you in the audience are lawyers? They'll put you to sleep. The Federal Rules of Civil Procedure. They look like procedural rules. They say things like, how many days between this and that will things take place? They describe things like discovery, motion practice, transcription, the appropriate place to file items, the languages, waiver, notice. These are fine procedural rules. Now you will read through these rules and you will ask yourself, well, what is the content of Jewish law? Where is the content of Jewish law described in these 35 rules? The answer is nowhere. The first rule says Jewish law is determined by the arbitrators, subject to review by the Av Beth Din, the head of the court. What rules? What substantive provisions? I'm so sorry. We're not telling you that, and we're not describing them at all. Thank you. But you want to know what language will the proceedings be in? They'll be in English. You want to know will they be transcribed? Yes. Do you want to know if you can bring your attorney? Of course. Do you want to know how many days you have to file an appeal? For certain, the rules describe all of these things. The substantive law that is applied, not mentioned at all. It's like a legal system that has a federal rules of civil procedure and nothing else. No federal code, no set of laws that are shared with you for you to describe. The second insight is you have to develop an appellate process. Jewish law does not intrinsically have an appellate process, but it permits one by contract. But allow me to describe to you a reality. To err is human. I think the person who said that was a Jew. No, never mind. To err is human. And all arbitration panels sometimes err. How come they err? Because the parties say, we will submit this by March 25th. And the arbitrator hearing the matter writes a 5 in a squiggly form, which is transcribed to a 3. And the notes say the matter will be closed on the 23rd. And the arbitrator then closes the matter on the 23rd, issues an opinion on the 24th. And what has he committed? Procedural error. If you don't have an appellate process to correct your mistakes, what happens? Somebody else does. And allow me to share with you who that somebody else is. That somebody else is a district court judge, whatever he's entitled, a Supreme Court judge in New York, a district court judge in Georgia. The lowest court judge looks at this arbitration procedure and he laughs. And he says, this is not enforceable. You said closed on the 25th, you closed on the 23rd, void. An appellate process is a necessary precondition to avoid reversal by the secular courts because arbitrators are human and they err. They sometimes err in judgment, they sometimes err in fact, and they sometimes say 2 + 2 is 5 and the award is 5. And then the judge laughs at that as well. An appellate court process forces the litigants, as a matter of procedural law, to appeal the decision within the rabbinical courts, make known their claims of error in advance, and allow the rabbinical court to correct its own error before they go to secular court. I'll go even further. We have laid claim to the idea that if you don't use the appellate process, maybe you've waived your chance to claim error in secular court, because there's a well-known doctrine of administrative review, which is you can't refuse to appeal to an administrative agency and run to a district court. It is, going back to our discussion earlier this morning, Chevron deference. You either appeal within the agency first before you go to secular court, or you waive your rights. An appellate review dramatically cuts down your reversal rate. In the time since the Beth of America started hearing civil cases 15 years ago, not a single matter has not been affirmed in the secular courts, although one was not affirmed at the district court level. That reversal was overturned, and it was affirmed on appeal. The appellate court process allows you to fix your own mistakes, because I promise you, those mistakes that you don't fix, somebody else will fix for you. Third, the rabbinical courts and the Shari'a courts and every other legal system that wishes to take advantage of these rules has to be sensitive to both religious and secular norms, so as to get the cases right. If you don't, in fact, understand what's going out there, what's going on out there on a commercial level, your own community will not come to you. Because while you are applying Jewish law, they are not. Allow me to give you an example to understand. Jewish law says, when I step into a supermarket and I pick up a can of spaghetti to put it in my cart, but I previously was holding something slippery, and the can of spaghetti fell to the ground and shattered and broke. A tragedy if there ever was one. I've bought it. So says Jewish law. That act of breakage is a purchase in the Jewish tradition. The Uniform Commercial Code makes it clear that that's not the case. When do I buy that can of spaghetti? At checkout. I didn't get to checkout. I didn't buy it. What happens in every supermarket in the United States? I turn around and walk away, hoping nobody saw me, and the PA system says, accident in aisle 6. Somebody goes to clean it up. They don't run after me and say, you bought it. They go after me and say, excuse me, there's spaghetti splatter on your legs. Do you need a towel? So the Jewish tradition recognizes this. When I run a supermarket, I could hang up a sign which says, if you're Jewish and you break it, you bought it. But if you're a Gentile, it's on us. But the Jewish tradition recognizes that that's not, in fact, the common commercial practice. The common commercial practice is to do what? To defer to secular law, so that even Jews defer to secular law on these matters. And the Jewish tradition is to generally buy and sell in accordance with secular norms. Maybe here and there are exceptions. Rabbis' contracts of employment are maybe done according to Jewish law. But even when you step into a kosher supermarket, there is no sign which says, if you break it and you're Jewish, you bought it. Not at all. Deals are done in accordance with secular law. If the rabbinical courts do not understand that norm, they arbitrate the cases wrong. Now, it's true, at some level, their wrong decisions are binding. But your litigants, your community will not come to you. Because when you win a case, that you know you should have lost. You say to yourself, "Boo, thank God I won that one, but I'm never going back to this panel in a case that I should win. Because just like I won this one when I should have lost, the next case that I should win, I could lose." Nobody really likes arbitrary justice unless you're an evil guy losing all the time. In which case, arbitrary sounds better than losing all the time. But businesses don't like arbitrary justice. They like the consistent application of the proper rules reflecting the intent of the parties. So Jewish law, and I think every other legal system, in fact, accepts a contract law norm, which is, really, contracts are about the intent of the parties. They're not about the Uniform Commercial Code or its Jewish cognate. They're about the intent of the parties. Dayanim, arbitrators, religious figures who sit in judgment of others on commercial disputes, need to understand what is going on in the field. They need to know when the community of the faithful are, in fact, conducting their business in accordance with secular law, and when are they conducting their business, in fact, in accordance with Jewish law. And I'll give you an example. The Jewish tradition has required since time immemorial that couples sign a prenuptial agreement called the ketubah. They don't actually sign it, they just accept it as valid and witnesses sign it. But it's been the custom for 1,000 years, more or less since the decree of Rabbeinu Gershon prohibiting polygamy, that the ketubah is not enforceable. And it isn't really enforced in Jewish law courts either. So you have here a religious legal system with a religious document that the system itself acknowledges is not enforceable. And this is even more so true when you have a legal system that enforces secular law, because when it looks out there, it says, oh, in reality, when two religious Jews buy a house in the city of Chicago, one religious Jew sells his house to another religious Jew, how do they sell that house? In accordance with the law of the state of Illinois and the city of Chicago. Could they sell it in accordance with a rule found in the Mishnah, which is you will build a fence around the house to indicate your ownership? Sure. But there are 1,000,001 excellent reasons why they don't do that. And in fact, the Mishnah itself, the Talmud really recognizes this with the term situmta. Situmta is the term in the Talmud for the common method of commercial transactions employed in the society that you are part of, and Jewish law recognizes that those transactions are most valid. What flows from this, by the way, is the use of arbitrators who know what's going on. You need to have arbitrators who understand their own religious system and much more. They need to understand the secular legal norms, and they not only need to understand the secular legal norms, they need to understand common commercial practice and custom. Because frequently, people's custom is not driven by Jewish law. And I'll share with you a secret. It's not always driven by secular law. Let's consider, for example, the sale of marijuana in many states of the United States. It is a crime under the law of the United States to sell medicinal marijuana. It is a crime. Somewhere there's a constitutional doctrine called the Supremacy Clause, which says states can't abrogate federal law, and indeed we more or less fought a civil war over this to establish this principle. And yet, when I look around in many states, what do I see? Marijuana pharmacies. Don't tell me it's a crime, it is a crime. But in fact, in the world we live in, these are properly done under a set of customs, common commercial customs, that are not necessarily legal. And the same thing is true with the speeding laws. I'm not a native of Chicago. In Atlanta, the highway that goes through Atlanta has a speed limit of 55. It's the intersection of two interstates called 75-85. And the joke in Atlanta is that's also the recommended speed limit, thank you. The posted speed limit is not the customary speed limit. You not only have to know Jewish law and secular law, or Sharia law and secular law, or evangelical Christian or canon law, you need to know secular law, and you need to know common commercial custom. Common commercial custom determines what people do. Shrewd rabbinical religious arbitrational panels, they not only pick people who are experts in Jewish law and experts in secular law, but when dealing with building construction matters, they find somebody who's an expert in construction law and dental law when dealing with dental malpractice. And since the Jewish tradition allows panels of 3, you don't have to find a person who's a Jewish law scholar, an American law scholar, and a skilled dentist. I'm sure there are such people, by the way, maybe even in this room. But you make up your panel by picking a little bit of this and a little bit of that. And between the 3 of them, they work out matters. And if you want to hear matters of child custody, you need to have a child psychologist. And the Jewish tradition recognizes that and doesn't strictly require that the arbitrators even be rabbis. Not at all. So you need to not only pick people who know something, you need to pick people who are skilled in understanding the norm out there. Secular law doesn't require that. The Federal Arbitration Act allows you to pick 3 blind mice, more or less, but your customers will not come to you if you select 3 blind mice. Now, of course, the Jewish tradition doesn't actually allow mice to serve as arbitrators, but you understand, I hope. But this is a balance, not just of what the Federal Arbitration Act allows, but this is a recitation of what your community insists, which is you need to appoint arbitrators who get it. They need to understand not just Jewish law, not just secular law, but the norms around you. So that's the 5th requirement. The 6th requirement is not a requirement, it's a consequence. When you build this rabbinical tribunal, you will discover that not only do you have a tribunal out there that people trust, you begin to assume roles in communal governance. Since you now have an arbitration panel that understands the reality around you, other organizations that have disputes, and it is inevitable that religious communities have not just disputes about buying houses and selling houses, but about territorial matters involving religious tribunals, or other such matters that pit religious institutions in dispute one with another. Now, I suppose at some level, when my 2 religious communities fight, if this were the old land, so to speak, the altar home in Europe, maybe I suppose in some religious communities we'd riot in the streets. That was never really the Jewish tradition, but maybe other faiths resolve these things that way. The Jewish tradition always recognized that if you had a rabbinic tribunal that the parties accepted and recognized, they would resolve these communal disputes. What flows then from the building of a tribunal with these 5 values is a 6th value, a significant role in communal governance. You no longer resolve disputes by hitting each other, which I think was never the Jewish tradition, or by shouting at each other, which maybe is the Jewish tradition, seeing who can scream louder. You now resolve these disputes by reference to a communal institution that's a well-established resolver of disputes. This then builds better communal governance, which increases the power, authority, and structural integrity of the Jewish community by dint of the fact that there is a common structure out there that we all defer to and accept. This is not a small thing. This is a powerful thing that over time changes your community from atomized individuals who can only tell you what they want to a larger communal structure in which we all agree that when we have a dispute that we can't resolve, here is where we go to resolve it. There is where we go, and this is how we'll resolve it. And this then begins to change the structure of your community. Indeed, Justice Menachem Elon observed centuries ago that Jews could engage in international commerce when no one else could, because if I was a Catholic Pole who wanted to sell shoes in Germany, I could not, because I would not deliver to you the shoes before you paid me, and you would not deliver to me the payment before I gave you the shoes, so we just stopped doing business. But if I actually wanted to sell those shoes to you, I, my Polish Catholic, sold it to a Polish Jew, in accordance with Polish law, who took it to Germany and sold it to a German Jew in Yiddish, the language they spoke, in accordance with Jewish law, the language that the legal system they both had, subject to the rabbinical courts that they both honored. And you, the German Jew, would then sell it to your local German customers in accordance with German law. Having a common language, common legal system, and common religious tribunal allows the resolution of common disputes and builds community. When we look to the secular legal system for how to build this, we recognize that our ability to build this system is driven very much by secular law norms. And I want to suggest to you, in fact, that there's a very good trend running in American law and many other legal systems, which I call the rise of contract. If you live in a legal system that functions based on sacrament, not only marriage sacrament, but sacrament in many other areas of law, they look at people with different legal rules and they say, I'm so sorry, your legal rules are wrong, because ours are sacred and yours are not holy. And by the way, American contract law was that way 100 years ago. But the Uniform Commercial Code makes it clear that contract law is driven by agreement. And one of the first things the UCC says is, any provision in this code can be changed by the agreement of the parties. We can agree to delete every 6th word. Our American legal system is moving more and more and faster into contract as the foundational doctrine. In contract as foundational doctrine, religious communities with well-written contracts thrive, prosper, and grow because definitions of sacrament vary. If we are to address ourselves well on the marriage issue, it's not because, and I say this not because in my heart I feel this way, but because in my political reality I understand this. It's not because we will agree with our secular society about who should marry, or what a civil union looks like, or what equal protection means. It's because the government will move to contract models of unions, and what will we do? We will write our own. Our contracts will be different than your contract, which will be different than your contract, which will be different than your contract. And indeed, within the Jewish tradition, there might be more than one contract that people sign. That's the joy of contracts. You can delete provision 6. The rise of contract as the fundamental basis of liberty is allowing the thriving growth of arbitration tribunals in the United States. On the other hand, we have to accept limitations. We have to recognize that our secular government will not permit certain kinds of exercises of authority. Police power is reserved to the state. The exercise of physically coercive authority will not be tolerated, and arbitration panels cannot order floggings. People have wanted to flog me. Some of them would like to flog you. A rabbinical court cannot say what this person needs to have done is he needs to be whipped or hit. Indeed, I think parties can't even consent to this, although I'm prepared to contemplate the possibility that a limited amount of physical punishment perhaps could be considered in consent. What are the limitations of contractual consent to violence? Ask a boxer. Boxers consent. You were in Chicago, so I'll say hockey players consent. People have certain limitations that they can consent to even, but certainly you have to recognize the limitation is coercive physical violence. Of course. If we don't recognize that, if we don't recognize the binding authority of the state in certain areas, then this model will never work. And by the way, the binding authority is not just in criminal matters. It's also in certain civil matters like bankruptcy law, where the bankruptcy code says after a party has filed for bankruptcy, no one may interfere with or seek to collect a debt that's under the stay of the bankruptcy court. If you don't know what this means, it doesn't matter. But sometimes the government exercises coercive, unique authority in civil matters. And then you have to accept that as well. But, and this is extremely important to understand, most areas are not like this. And if anything, the trend is to move further and deeper into contract and less into sacrament governmental values that you cannot opt out of at all. So we are living in a society in which, as secular values become normal, and not only does the Judaic tradition recede to the background, but the Judeo-Christian tradition recedes to the background. Never mind many other religions. The government is going to replace this with occasional assertions of governmental authority, but frequently with assertions of contractarian authority. And religious tribunals can thrive in contractarian environments. And by the way, this is not limited to traditional Jewish law communities. This allows the creation of contracts between people in a same-sex marriage. And it's no secret that when same-sex marriages were illegal throughout the United States, the gay and lesbian community used contracts to govern their relationships. Now these contracts have, if you'll excuse me, come out of the closet, which is fine. The government is more open to the realization that people will structure their relationship around contract rather than around sacrament. One final observation is really important. The secular society can be suffocated sometimes. Somebody referred to the one of the speakers referred to the secular legal norms in France as suffocating. And it's true. Secular society holds out the possibility, when it's coercive and doesn't allow you to opt out through contract, of imposing upon us suffocating secular values. What's going on here is very important to understand. Religious communities, Sharia courts, Jewish law courts, evangelical Christian courts, canon law courts, I'm sure Hindu courts, and so on, are recognizing that on matters in which they are unique and have different cultural values, they must opt out of society to avoid this suffocation. Because we don't believe in, for example, unilateral no-fault divorce. Or maybe some of us don't believe in divorce at all. Maybe some of us don't believe in marriage at all. Whatever exactly it is, if religious communities are to avoid suffocating in this secular community, it's because the secular society recognizes our right to contract out, and we are smart enough to recognize the 6 procedural rules necessary to successfully opt out, implement them, and build our community. This community will be gloriously deviant, each in its own way, each sharing its religious values in a grand whole, making up the diverse religious communities that are the United States. Thank you very much.
Thank you, Director Broyde, and we have time for some questions. Yes, sir. Oh, Professor Novak, please.
Well, I mean, the advocacy of panels of arbitration is laudable. Inasmuch as you indicated that they, really have to understand the secular reality. Well, the question is, they're going to really adhere to it more or less. And what do we need them for at all? Well, they bring things down to a much more local community level. It's what Catholics call subsidiarity, decided at a lower level. The problem is as follows. Let me give you the following case. It came to me. A certain rabbi in my community of Toronto referred to a certain well-known Jewish personality in public as a charlatan. This Jewish personality sued the rabbi for slander in secular court. I was phoned by the lawyer representing the Jewish personality who said that the rabbi has suggested that they should not go to a civil court and should go to a Beth Din. My answer to the person was as follows. I said, I'm going to be a witness in this for a variety of reasons, but I'll give you a piece of advice. I could disqualify any rabbinic court that this was submitted to because they are all colleagues of this rabbi. Therefore, the notion is that by submitting it to a secular court, we're out of this notion of where someone is somebody's colleague, et cetera, et cetera, et cetera. In other words, the problem is that this will only work in a specifically defined area of the Jewish community of which these people, but if you have somebody from Jewish community A and Jewish community B, which are antagonistic to one another, even to more in Hasidic sense, then the point is it's far better for it to be submitted to a totally impartial third party, which is going to turn out to be the secular court. How do you think that I gave the right advice to this person?
So I think that rabbinical courts have to create a deep procedural commitment to impartiality. This is not hard. It used to be that travel was difficult. We live in a country in which you can travel from point A to point B, far away places easily. It should not be hard, and indeed it is not, hard to craft rabbinical courts in which judges travel from place A to place B when they encounter matters where the local judges ought to be recused. So I won't disagree with you that sometimes there is a problem of partiality. But I don't find this to be an unsolvable problem conceptually or an unsolvable problem practically. Within the Northeast, everything is an easy flight, and throughout the United States, everything is a relatively easy flight. It is not difficult or complicated to find qualified rabbinical court judges who sit outside of their area. This is not difficult. So I would say, of course, you have highlighted a problem, a procedural problem that is worthy of focus and addressing, but not an overwhelmingly practical problem at all. It used to be more problematic when the typical person traveled no more than 25 miles from his home in his lifetime. Many of us travel more than 25 miles from our home daily. And who in the room here lives in the same city they were born in? So yes, it's definitely a problem, but it's not an unsolvable problem at all in any way, shape, or form.
Any other questions? Yes.
I guess I just wanted to follow up on that. I can't help myself but worry. Just also in that case, the only place where the detained person will not get a hearing, at least in the United States, is in court. Because in that type of case, you'd have a rabbi who would be able to say the First Amendment prevents the court from adjudicating the case. The only place he's got a chance of being getting some sort of damages is actually before rabbinical court. So the law may be different in Canada, but under those circumstances, the last thing I would recommend for somebody to do is to go to court and then be shielded from at least in America, I don't know if it works, I'm curious to know if it works differently in Canada. The only place you won't, in the U.S., the only place you won't get a hearing is in court because courts will dismiss on First Amendment grounds.
Just the last I heard, they settled out of court.
Yeah.
Which meant that the rabbi did have to pay something, probably far less than what a civil judgment. But also just in response to Rabbi Broyde, if I were, let's say, involved in litigation with a rabbi who is a member of your rabbinical organization, irrespective of where he lives, I think that it would be wise if you recuse yourself from sitting on our case, irrespective of whether it's not local or not, because people belong to international organizations.
I won't disagree with that, but that too is just a technical problem. It's easy to find independent rabbis who are in fact fiercely independent. And I actually want to use Professor Helfand's example to focus on a slightly different reflection, which is this is an example where the Jewish tradition would treat the substantive case differently than the secular American tradition. The secular American tradition would in fact give the rabbi a great deal of First Amendment right to slander you from the pulpit. Something that the Jewish tradition would not necessarily give you. Contractarian grounds here inspire me to think that it would be reasonable in those situations to say the members of the synagogue perhaps intended this to be judged by Jewish law. But I don't really know, but if we had vigorous contracts that govern these relationships, we'd have a clearer understanding of what are the membership rules in any given synagogue. It's a fascinating example reflecting of a very important reality, which is sometimes religious rules on the ground are the same. Sometimes religious rules on the ground are a little bit different. Sometimes religious rules on the ground give you less freedom than the secular rules on the ground give exactly the same way.
Yes.
You've talked quite a bit about the Beth of America, and I'm curious, you've obviously been in the news a little bit recently. Can you talk a little bit about your future and how you're going to continue to interact with that organization?
No. I'm sorry, it's a good question, but I can't.
I have a question. Following up from this morning, the issue of women's incapacity under Jewish law with regard to the giving of testimony. Could you give us some sense of how that has played out within the arbitration context?
Sure, it's an excellent example. More than 500 years ago, Jewish law adopted the rule that in a rabbinical court testimony about what has actually happened, everybody testifies, men and women, Jews and Gentiles, adults and children. There's almost no incapacity as to who can testify, and the types of incapacity as to who can testify are the kinds that are obvious. Those who are mentally incapacitated cannot testify, although the Jewish tradition does restrict what we might call in Hebrew edut, the kind of formal witnessing that you need to perform a marriage or a divorce. Functional in the rabbinical courts, everybody testifies. You bring witnesses, the witnesses testify. Almost nobody who's a reasonable witness is told you may not testify. And it's not that it's been that way since yesterday. It's been that way for the last 500 years, more or less. And this just doesn't seem to be a significant issue.
Any other questions? Yes.
How did that change?
That's a topic on substantive Jewish law. I'll give you an outline without an exact answer. The Jewish tradition draws a distinction between witnesses that make an event, what we call in Hebrew edei kiyum, and witnesses that merely attest to events that happen, called edei raya. And we have a much longer tradition that witnesses that testify to what happened are easily recognized as valid testimony, no different than a fingerprint or a video camera. And since, in fact, in those circumstances about what happened, circumstantial evidence is admitted, evidence about what happened through testimonial evidence is no worse than circumstantial evidence, which is, of course, totally and completely admissible. So when somebody comes to me and says, Mrs. So-and-so wants to remarry, what's the first question I ask? Was she divorced? And the witness says, no, her husband was killed. So I say, how do I know her husband was killed? And they pull out a head, not attached to the body. Is that proof that the husband was killed? Of course. Now, at some level, that's circumstantial proof. But the Jewish tradition recognizes circumstantial proof as valid for establishing facts, rather than necessarily for establishing marriage or divorce. So we are open to video testimony, we are open to dental records, we are open to fingerprints, we are open to almost every form of circumstantial evidence you could imagine to establish facts for commercial disputes, and invalid witnesses are no less than circumstantial evidence. That's a rough outline of 2,000 years of jurisprudence in a particular area of Jewish law. I'm sure that I've left something out. Indeed, I can think of things already that I've left out, but that's a topic for a class rather than a footnote.
All right. Any other questions? Well, I'd like everybody to thank Professor Broyde for his talk. Thank you.